He's studying to get his diploma in European patent litigation under the new unitary patent system. He, with his co-authors, continues to edit and update the book, European Patent Law for U.S. Attorneys, so he's very well situated to moderate this panel. And Ed, take it away.
Thank you, David. All right. Here we are. All right, great. Thank you all for coming. I appreciate this. I agree with David that this is an extremely important topic. I think it's going to be surprising to U.S. attorneys how important this topic actually is. But to make it more accessible and to give more information, we have an excellent panel. I'm going to just do a quick introduction, if that's okay. We're going to start with Sabine Ager, and she has dedicated herself to patent litigation for more than 20 years. She's particularly involved in matters with cross-border aspects, implying multiple parallel foreign litigations. She has particular expertise in matters relating to electronics and telecommunications and standard essential patents. And just move it along, she's also working on a case very similar to one that was discussed earlier by Judge Young, only she's in the Parisian court. Is it in Paris?
Yes.
There we are. Very nice. Well, good. And then we have, to her right, Chris Carroll. Chris is an intellectual property partner at Burns & Levinson, both in the Boston office and in the London office. He's practiced extensively before both the U.S. Patent Office and the European Patent Office. He has extensive experience drafting and prosecuting U.S. and European patent applications, and he's also been lead counsel for oppositions and appeals at the European Patent Office, including arguing before the Examination Division, the Opposition Division, and the Boards of Appeals. Before that, he was in the Navy, and he is the named inventor on multiple U.S. patents related to wireless security. And then we have Matthias Kalhuber, who came and by the way, Sabina and Matthias came from Europe, so we are very grateful for their attendance today and their great effort to get here. Matthias is an IP expert with more than 25 years experience in the fields of medical devices, electronic program guides, software and data security, semiconductor lithography systems, micromechanics, railway technology, crash safety, aerodynamics, and general mechanical engineering. He studied in Munich, Hamburg, and Chicago. Matthias obtained a master's degree in mechanical engineering in 1995 before qualifying as a German and European patent attorney in 1999. He is a partner at Kohlhaas and Floreck, and he is primarily concerned with obtaining and attacking and defending IP rights, doing a lot of patent prosecution at the European Patent Office, and an awful lot of opposition. He actually had an opposition this morning with the European Patent Office, which he conducted by video conference before coming to this conference, which I thought was very kind of him. And on the far right, we have Kevin Brayton McGough. Kevin McGough is the Vice President and Associate General Counsel of Intellectual Property at Butterfly Network. He's got a BS in Mechanical Engineering from Lafayette College, and his JD is from the University of New Hampshire. He has served as the IP Legal Department of Schlumberger, the world's largest oil field services company, for 14 years, with positions in Houston, Oslo, Cambridge, and Massachusetts. He is now the Chief IP Counsel at Butterfly Network, and he's particularly well suited to help with this program because he's got a very good understanding about how U.S. attorneys can misunderstand or lack certain information about how the European system works. Having lived in Norway for a period of time as a patent attorney, he's got great experience in this area. So I'm going to begin, if that's okay, with just a very short introduction of what we're going to talk about, then turn things over to our panelists. We're going to talk about the Unified Patent Court. And the European Union has taken a lot of steps over the last few years to go ahead and change the way intellectual property law works in the European Union for the benefit of the European Union companies. We talked a lot earlier today about the law, how the law develops, whether or not we're going too far, how we should actually deal with examination, and that's great. This is not a legal change. This is a change that's being driven by economic interest. The European Union wants the European Union to succeed. They've looked at the differences in the tech companies that are in the native to European countries, and they look at what they see in Silicon Valley, they look at what they see in China, and they see a discrepancy that's uncomfortable to them. They're trying to do the kinds of things they can actually do to change that discrepancy, and part of that is to go ahead and to change the way intellectual property rights in Europe, whether it's patents or trade secrets or copyrights, are valued. And to that end, they've passed a raft of different legislation for changing data rights, for changing trade secrets, but the crown jewel, in my opinion, and I think my opinion matters, but the crown jewel is going to be the Unified Patent Court. The Unified Patent Court is going to be a court that's going to replace the current existing system for patent litigation in Europe, which I will say, and I don't expect anybody else to say, is cumbersome. Excellent systems, great attorneys, great judges, but it's a very cumbersome system. They're going to replace it with a centralized system, and our experts are going to talk about it. But before they talk about it, they're going to confront the elephant in the room, which is it going to happen? I have had this conversation more times than I care to admit. I've been a supporter of the UPC for over a decade when I was a younger man, but now we're going to actually turn over to Sabine. There we go. We'll turn over to Sabine and Matthias to give us their input on whether or not the Unified Patent Court is going to happen and what they think about that. And now I'm going to take my seat.
Thank you.
Sabine, you want to start or should I? Whatever. Okay, just as Ed just said, I'm in that profession for more than 25 years now. And the UPC was always there. It was always said it would come. So now it's finally there. So I'm pretty sure that it's gonna happen. This is fingers crossed. Okay, but there's very little that could happen. I think pretty much everything is done. We're waiting essentially for my country, for Germany, to take that instrument of ratification, which is there, which is signed, everything's done. Carry it next door because Germany is the one where everything has to be deposited. So basically, just walk that out the door, go to the next door and deposit it. So this is what's still missing. Germany's always had at least for the UPC the role of the gatekeeper. So that was clear from the very beginning that we would be the last ones to ratify, to make that fly. And it's not going to happen. This is why there is still a bit uncertainty until the German government is sure that it actually works. Everything is there, so staff is there, the case management system works, etc., etc. That's what we are waiting for. That's what's currently underway. That's what's currently happening. So the judges are staffed. They are pretty much there.
Almost trained.
Yeah.
Yeah,
Okay.
maybe what we can provide as an indication that we're nearly there. I mean, the judges have been selected. There will be legal judges and technical judges. The legal judges have been appointed. Some of them will be part-time, some of them will be full-time judges before the UPC. The technical judges will be mostly like you, Matthias, I mean, part-time patent attorneys have been selected. They have been trained already 2 weeks ago in Paris. The legal judges will be trained in January next year. And the roadmap, which has been published on the website of the UPC Court last Friday, mentions that the sunrise period, which is these 3 months which will happen between the date on which ratification will be complete and the court will truly take the first case, will start, we expect, beginning January, meaning that the first case should be filed on the beginning of April. Well, I'm not sure that would be a very good indication.
Well, everyone looked at it. April 1st, really? Is that a joke?
But, yeah, but I mean, we've never been so close.
Yeah. So this is it. So pretty much everyone is fairly confident that this is actually going to fly.
And could you take a minute just to kind of set the field? We've got a wonderful slide behind us. If you could take a minute just to kind of walk through what the Unified Patent System is going to look like, and also a little contrasting to what's currently in place and how it's different from that.
So, if you want.
Yeah, maybe I can do that. Of course, you know that currently the system in Europe is very fragmented. I mean, you have, in the best situation, you have for one country, one specialized court and one court of appeal. But in other countries like Germany, you have many courts which have jurisdiction over patent litigation in first instance, then several court of appeal. And in some countries, to make it even better, you have a bifurcated system in which you have courts dealing with infringement and courts dealing with validity. So that makes it even more complex. The new system is, I would say, as always in Europe, a political compromise because it will still have a number of local divisions, so still a fragmented system in first instance. Meaning that you will have a number of countries in which you will have one local division, and Germany, as always, will have more.
We have more.
So again, fragmentation in first instance, but what will be new is that you will have only one court of appeal, and if you want to compare it to the US, in fact, the system will be very close. You will have a number of district courts in first instance, but you will have one court of appeal, and obviously what we expect is that this court of appeal will unify or align the case law, which is very much needed.
Yeah, that's essentially the purpose of
Yes.
it. Yeah, well, as with any appeal court.
Yes. So that's for the structure. Do you want me to go on with the other features? Or?
Yeah, if you could talk a little bit about that, maybe, and also if you could pick at one point, talk a little bit about the unitary patent and unitary effect.
Yes.
Yes.
Maybe pattern that should be human.
Yeah, okay, good. So we've got this unified patent court, which is basically, as we've seen, as you see on the screen here, which is the court of first instance, which has its local divisions and so-called regional divisions, where countries have joined and just have one court for several countries. That's what we have. We have a central division as well in that court of first instance, which is essentially responsible for nullity, and the local divisions can refer cases to the central division. But that's pretty much it. It's that one instance that you go through, and then in parallel to that we have the unitary patent, and the unitary patent is basically a European patent. So you go through the normal grant procedure of a European patent, and then at the, I don't know if you're familiar with the European patent system. At the end of the day, you get your European patent granted with the EPO, and then you had to decide, okay, I want to go to Germany, I want to go to France, I want to go to the UK, whatever. And now with the unitary patent, it is another option that you have after your European patent has been granted. You can pick the unitary patent. We call it validation, so you validate your European patent, and typically you have those individual countries, but now you can choose the unitary patent as a validation. It's pretty much the same thing, slightly different in the procedure, but essentially the same thing. And then you can cover the member states that participate in that system with one patent, one unitary patent. You can't pick. You either have to take. If you want to cover France or Germany, for example, you can't say, oh, I want to have the unitary patent and I want to have France. You have to make a decision. Any country that falls under that system, under the unitary patent, you can either cover it with the unitary patent or with an individual validation. So you're not forced to, you have the choice. But yeah, it has an impact on whether or not the court is competent over that patent. And that's pretty much for the unitary patent. That's pretty much it. So you will have to decide, do I want to have the whole thing in one shot? With the downside of being unitary, it's there is no, you can't selectively abandon it, for example, as you could with the individual patents, and it's subject to a central attack. When you lose it, it's gone for all the member states that are covered. So that's pretty much it. Bringing me to the sunrise period and the big question. The Unified Patent Court has not only jurisdiction over those unitary patents, but over all European patents, existing and future. So they will have jurisdiction over these unless, and this is why there is the big fuss about the sunrise period, unless you as a patentee decide, I want to opt out. I don't want my patent to be under the jurisdiction of the Unified Patent Court. I want it to be in the old system. You can do that, you have to do that within the sunrise period. It's advisable to do that, because otherwise, if you don't do it, if you do it 2 days too late and someone else files an attack, a central attack before the unitary patent, then all the family members of that patent are affected by it. So you have to decide: do I opt out? Do I take this out of the jurisdiction of the Unified Patent Court, because the risk is the central attack against the patent. You lose the benefit of enforcing it centrally, but and that's the major concern. That's the major concern for many of our clients, I'd say. what about this central attack? It's you put something, and we had a discussion about NPEs, non-practicing entities. What will they do? And I think that's the major risk for them. If they use the UPC, if they use that system, they basically risk their patent being killed in one shot, which is inevitably going to happen if they enforce it.
Excellent. Good. So, just good. Did it get recorded? So essentially now it becomes a much simpler system, because if you want to, and it always would be that your CEO would ask you, do we, as a patent attorney, your client would ask you, do we have a patent in Europe? And you always used to say, well, we have, yes, well, actually there's one in Germany and one in France, and we have one in the Netherlands, I don't know why, and we have one in, and now you get to say yes. And it's so much easier to be able to sit there and say, yes, I have a patent. Unitary effect means I have one throughout Europe. To the extent you can understand what Western Europe is as an American, it is a patent that covers Europe, which is a very good and helpful thing. But if it's a patent with unitary effect, it automatically goes under the jurisdiction of the unified patent, right? If I did go the old way though, which is still going to be an option, you don't have to take with unitary effect. If I do get a German patent and a French patent, what for the transition period happens? Do both kinds of courts have jurisdiction? If you could talk a little bit about that, what's going to happen during the transition period, that'd be terrific.
You can do this?
Yeah.
I mean, or anyone else?
Yeah.
Not just us?
No?
I'm just here to keep
Okay.
Germany separate.
Germany and France.
But we don't fight, no longer.
He's Belgium.
Yes, we do have provisions. I mean, obviously, because the system is so different than what we have currently. I mean, it's been decided that we should go into the new system progressively. And so during a transition period, which is meant to last 7 years and could be 14 years, you will still have the option of litigating before national court. So let's assume that you have a European patent for which you have not opted out. And so you can decide, depending on where is the infringement, who is the defendant, whether you believe that your patent is very strong, you don't really fear that the central attack on invalidity will be an issue, then you can go before the UPC. You think your patent is not so strong, maybe you've opted out, but if you've not opted out, then you could decide to go before a national court, and that could be even making sense if you have just infringement in one country, and the hassle and cost of the UPC litigation would be pointless. So during this transition period, mostly we expect that the forum shopping will be broader than ever, because you will have the UPC, and within the UPC you will have to pick the local division in which you will have to start your case. But on top of this, you will have the option of starting your litigation before any national court. So we lawyers will have fun.
A lot to do.
And if you do go to the Unified Patent Court, let's say there's the case that you get brought to the Unified Patent Court. If the Unified Patent Court renders a decision, from an economic point of view, how broad is that decision? What does it cover? What would an injunction look like? Under the existing system, if you would get a German patent and a French patent, I would go to the German court. It would determine validity. It would determine whether or not there's infringement and what kind of damages would happen. France would take it up separately, make their own decision as to validity,
Which
make
may
their
be
own,
different.
which might be different.
Might be
absolutely.
different.
Yeah.
Under the existing system, how does it actually work? When the courts make a decision, what's the outcome?
Thank you, the litigation.
Yeah. Well, maybe what should be said is that from day one of the court, the number of countries who have ratified so far, including Germany, because it's almost done, are 17 EU member states. And some of the other EU member states, Ireland and others, have signed but not ratified. So we expect that the number will be growing. But so just imagine, to go to your question, you start a case before the UPC and you obtain an injunction. It will be covering from day one, at least for a unitary patent, and if it is a European patent, as long as it has designated all the 17 countries, it will cover a market of 17 EU member states, which is huge.
Absolutely huge.
And so that doesn't include Spain, which didn't want to go into the systems. That doesn't include Poland, which is a big market and didn't want to be part of the system for political reasons. But for the rest of it, you have most of the big market
Pretty
in
much
Europe.
everything, yeah.
So that's in terms of impact. Obviously, I mean, that's the reason why we say that may shift litigation from the US to the EU, at least for, I would say, pan-European infringement or I would say, worldwide infringement, just because the market would be merely of the same size.
Mm-hmm. And so the possibility is there that you would start to see litigation, pan-jurisdiction litigation, move out of the United States and over to Europe. And is the UPC system going to be fast and cheap? Is it going to be fast and cheap in comparison to the US litigation system? Can you talk a little bit about that? And then we'll move on to a couple of other topics.
Yeah, a couple of other questions. Just ask.
Yeah, because I feel bad for the other panelists.
okay.
Maybe I'll reply to this one and then shut up. What's interesting, and that really reflects on what Judge Young was saying this morning, and he said, the problem with the US system is speed. And I think at least the expectation for this new system is that it will be very quick. Because we have rules saying that between the day the statement of claim is filed and the day the judgment is issued, you should have 1 year. Meaning that that will be very quick. It will be mostly a written system, meaning that you won't have discovery, you will have a very limited use of experts and witnesses, 1 day of hearing. So it is meant to be a very efficient system and very, very quick system. In terms of cost, obviously, because the litigation will be covering a lot of, a very vast territory, we do expect that because we want to turn every stone, it may be a bit more expensive than national proceedings are currently, but I think that will not compare to the US, just because we will have a very short trial, no discovery. I mean, so all the phases in the US, which are costly, will not be there.
Got it.
So fee-wise, it should be, roughly from my experience, it should be somewhere in the ballpark of German proceedings.
Got it.
For the moment, so it's
So and then just for people, that is much lower than U.S. litigation. Now, for our U.S. friends who have been so helpful, this is a big change, and it's a big change that's going to happen overseas. But we do go for European rights in the United States. Chris and Kevin, can you talk a little bit about what this means for U.S. companies who could be sued by someone and brought into a court in Europe, or is interested in securing patents in Europe? Can you talk a bit about what this actually means for the U.S. practitioner?
well, let's start with the
All right.
We're the client. I think we're going to go from a situation, Ed, where we used to really, really like European patents to where we're absolutely infatuated with them.
Okay.
We are going to love them. I think you're going to see a situation where we stop first filing litigation in the United States.
Interesting.
I think if the UPC is under $5 million, that'll be the first strike. For a couple of reasons. One will be the cost. Two will be that you'll have a resolution before you get through discovery in the U.S. So you really have a good sense of how the case was going to play out. I think you're going to see people immediately run to IPRs in the U.S. in reaction to the initial filing in Europe.
Interesting.
It'll take the United States a couple of years to catch on to this. So probably in 2 years you'll see the exponential increase really take effect. But as far as the European patent, this is going to not be a doubling of the value. This will be a multiplier effect.
Interesting.
An absolute multiplier effect. It's going to affect a lot of the secondary countries that used to be filed in. A lot of companies are going to solely select Europe, China, and the United States now. All other secondary countries in that region that are not in the UPC will see. My guess is,
So you think they'll
except for pharma companies. Pharma companies have to
Yeah.
file in every country, but for mechanical-based companies, electromechanical, things that you have to bring into port in the Netherlands.
So you think it's just going to be cost management? It's just going to people are going to say, look, we're going to concentrate our patent position now in U.S., Europe, and China, and I'm not worrying about Korea, and I'm not worrying about Australia, or what do you see?
Those are out. So who's not in the UPC? Spain.
Right.
I will probably never file another patent in Spain, or even think about it. We're going to do. I think a lot of companies will say, for outside of extremely valuable patents. Of course, outside pharma. Pharma has a file everywhere.
Yeah.
It'll be Europe, China, United States. That's, as you've noted, 75% of GDP or something, or 2/3 of the world GDP.
Yep.
When we make filing decisions internally, companies are not necessarily looking to put a chip on every spot. We just need to have enough chips so that it's not financially logical for a company to make the capital expenditures to come to market. If you can't sell in 3/4 of Europe, why would you?
Yeah.
Would you bother?
That's all you need. So it's going to be great until it's not great.
We're gonna get that in a minute, but we're getting there. Chris,
Well, I would say it's fitting that this is a program on innovation and entrepreneurship because I think the Unified Patent Court is an innovation engine. The Europeans, have been looking at how to increase the ability of their companies to compete in the international market. If you look at Forbes' list of your top digital companies, there's only one European company in that top 20. It's Deutsche Telekom. The other 15 others are American companies: Apple, Microsoft, Alphabet, Facebook. And then the other ones are Asian companies, including Samsung, whatever. So the most educated population on the planet is in Europe, I think. And so they're looking at themselves, and they've been thinking, and this is at the political and the economic level, they've been thinking about why. Why are we not able to compete against America or the Asians? What's going on? And an issue that they've picked up on is they've looked back at our past. They've looked back at when the CFC was formed in '82, and they saw the Polaroid Kodak decision where Polaroid was given $1 billion in an injunction against Kodak. And right after that, that's when U.S. patents, the value of U.S. patents exploded. And then you went to the golden age of U.S. patents. Well, guess what they want to do now here? Because this Unified Patent Court will leverage the full market of Europe, depending on what patents they have. And it will issue injunctions. It will have the ability to do that. That's going to raise the value of European patents up. And now you have to think about the U.S. market's a $20 trillion market. Well, Europe is pretty close to that, and with the UK, they were a little bit bigger than us, but they're still pretty close. So you're talking about, I know we're looking directly at the efficiency of this court and the advantages of it, but there's a push at a higher level, and there's an objective of the UPC to raise the value of European patents, which in turn they hope will eventually, infuse more money into startups. Right, banks, now there's fully collateral.
Yeah.
There'll be more collateral. And at some point, maybe the next Google will come out of Paris or Munich. And so I think the ultimate point is here, the objective of this court is to enforce patents. Kind of like the objective of the PTAB was to kill patents. And it succeeded, right? People were skeptical in the beginning. They said, who's going to use this court? There's estoppel issues in the U.S. We're not going to use the PTAB. Well, PTAB started killing patents, and now it's changed the whole landscape of U.S. patent law, right? And now that's basically how you have a bifurcated system. That's how you do it in the U.S. Guess what? Once this court gets a big judgment, this UPC, in an injunction against a big company like Google or Apple or something like that, boom, that European patent. And as Kevin alluded to, people are going to start to rush to that forum. Now, maybe it'll open a Pandora's box, which I think you were about to get into, which is, how disruptive are injunctions, right? To, things like that. But still, I think from a political leadership perspective, even beyond, what the European practitioners are seeing, maybe not seeing the forest through the trees, but I think it's more of an economic incentive that they want to sort of boost the innovation capability of Europe ultimately, and that's why this court will succeed, because there will be incentive for that court, for the UPC, to enforce patents.
Can you, before we get to the MPE issue, can you and Kevin talk a little bit about, it's a European court for European law, and you've got to be prepared with a patent that's prepared for scrutiny under that law?
Well, I think that's, and Matthias could address this too, but part of the issue in the U.S., why do we have this 10-year period in the U.S. of basically attacking patents, knocking down the value of patents? You had Alice, you have the PTAB, right? Why was it? It was MPEs. They were leveraging, they were taking advantage of the U.S. system, about, expensive discovery. They could do foreign shopping, let's say in the Eastern District of Texas. So they could game the system to basically hold big companies hostage. And so they reacted, right? And they said, we need tools that district courts and the system can use to kill these, the trolls, the patents, the type of enforcement. So in the creation of the UPC, Kevin Mooney and, Sabine and, and lots of folks like Matthias, thought about this, and they, once again, they looked at the issues in the U.S. and they said, well, we're going to do we're going to structure the UPC in a number of ways to mitigate that, to prevent it. And there are things. So one thing is, you use
And this is
judges.
to mitigate NPEs from being
Yeah,
successful.
it's to mitigate forum shopping. Depending on how many cases a local division has, they can only have maybe one judge, or central divisions are another story. But the judges aren't permanently appointed. So you got the Eastern District of Texas. You have district court judges that are just blowing off, everyone else because they have to get impeached by the Senate. So that's not going to happen. But at the UPC, it'll be a 6-year term. So if they're bad actors, they're not going to get readmitted.
Cost.
So,
I think
yeah.
you'll be reimbursed of your cost.
Yes.
So,
And that's a big thing. Losing party pays in Europe,
Yes.
which is huge. In the U.S. that's not the case. So I think the issue is,
Yes. You can.
But
Yeah.
not full. But,
Not full, it's capped.
It's
Yeah.
capped.
It's capped, basically, it's a statutory fees essentially,
Got it.
and it's capped. So
Statutory fees.
it depends on the value in dispute.
Mhm.
Yeah.
The fees depend on it. There's a fixed fee plus then depending on where you go. So it's the fixed fee for infringement, nullity, up to a value of 500,000 euros, and if it goes beyond, then it's always depending on how much it is. So it increases, but it's fairly similar to.
So that's interesting. So to a certain extent, losing party pays, but it may be capped a bit, but it's still probably enough to discourage someone from gambling. They're probably going to start with a good patent.
For the 500,
They're gonna go
just very briefly, for a 500,000 euro value dispute, I think the cap is at 80,000 euros that you can recover max as the winning party from the losing party. So it's still a substantial amount of money, certainly.
Yeah, no, I mean, that's good. And, but I think that the ultimate point here is that MPs, I think, will test the system, but they're going to be more selective. And, one argument about the patent system is, who cares who owns a patent? If it's a good patent, right, then why can't anyone enforce it? And so there are a number of structural components, I think, in the UPC that will mitigate the type of abuse, I think, that was perpetrated by MPEs in the U.S.
Kevin, as in-house counsel, what's your concern on NPEs in Europe with the new European system?
I'll tell you the truth. When we look at negative situations, there's two totally disparate aspects of it that we look at. One is the financial aspect. Yes, bad, stinks, write a check at the end of the money. At the end of the day, it stinks to have to pay somebody. That's what MPEs want. They will always walk away for the right check. So they're actually generally of lower concern to companies, operators. And I'm sure that the UPC is going to play out a lot like it has in the United States with NPEs, is that the bar to get an injunction will end up being higher. Non-practicing entities, they have a much harder argument. They're annoying, they cost money. The ones that are really going to be terrifying are going to be competitors, where at the end of the day it's an injunction. And like you started out with, when you tell your boss, do we have a patent in Europe? Yeah, we have a patent in Europe. That's great. The hard conversations are, we've just been sued by one of our competitors. Well, how much are we going to have to pay? Well, I don't know. Well, what else could happen? Well, in 2 years we could be enjoined. Where? Well, Europe. That's a hard conversation.
Yeah.
But yeah, on the NP, on the non-practicing entity thing, it'll be interesting. I think it's really in the control of the court. The court has a lot of leeway to either tamp them down or to let them flourish like they have in the United States. There's a lot of leeway for, I think, the UPC to handle that. But yeah, at the end of the day, they want money. money will
Right.
make them go away. Generally.
Yeah, that's it. And it's always, well, you always consider, well, do I take the risk and not settle at an early stage, or that's the major downside of that. That you're forced to make that economic decision, more or less.
They are easier to deal with because they're rational actors,
Right.
and they're just looking at it as a business case. So, in-house counsel and companies will generally do a reasonably good job of valuing what the value is.
Yeah.
And the chances of the two sides coming together are reasonably high. Most time, the vast majority of the NP, the non-practicing entity activity is going to be around standard essential stuff. That'll probably be the initial wave of non-practicing entity activity.
So, getting back to the point you had, drafting, make your patent applications EPO ready, because that's what we're talking about. I think that is a major difference between the EPO and the USPTO. NPEs have been fairly successful because what got out of the USPTO is no comparison to to how restrictive the EPO is when it comes to support.
Yeah.
So divisional applications, what can I squeeze out of my patent application? So you have way less wiggle room to do that with the EPO. So we see, I wouldn't say higher quality patents, but it's way harder to really tweak your patent application or your divisional application to the ultimate. That's what we see. It's really hard to do.
It's a much better examination.
Yeah, it's much better examination, and you have way less room to tweak and stretch your original disclosure.
Well, I think we should categorize. There's two flavors of NPE, non-practicing entities. There's the quote-unquote trolls that are really just extortionists.
Yeah.
They'll get to some bar, or, get some reasonable argument that maybe they can carry it into litigation. You have to spend money, and they just want to check. But I mean, there's a lot of non-practicing entities that own real patents.
Right.
Yeah,
Qualcomm.
It's a good idea.
You have big companies have
All the way
licensing.
from Nokia and Qualcomm that are real companies
Yeah.
that are just acting like non-practicing entities in certain ways.
Yeah.
All the way down to non-practicing entities that actually are, smart about it. They have smart people. They're well funded. They're out buying good patents, and they're not bringing frivolous cases necessarily.
But I would say this. I mean, I know we're talking about NPEs, but I'm just more concerned about the mission of this court will be to enforce European patents.
Mhm.
And there'll be entities that will go after large American companies. And this court will, its mission is to enforce patents. So, I mean, U.S. companies need to be ready for this court and need to be prepared to deal with a court that I think will be plaintiff biased. I think there'll be a lot of incentive for this court to deliver big judgments. To basically raise the value of European IP and European patents especially, right?
And it looks like it's a very low-touch court in some ways, and that much of it is done online. Like you mentioned, the CMS system. It doesn't sound like there's a lot of hearings. Can we talk a little bit about just like the structure of what it actually looks like to bring a case?
I can do that.
Please,
Yeah.
that'd be good.
So mostly, the proceeding will be split in three phases. The first one, which will be written proceedings. So mostly it's filing a statement of claim. It will be a front-loaded system, meaning that as a claimant, you will have to bring evidence of your claims up front.
And how front-loaded when you say that? Because in the U.S. we have standards we have to apply
Yes.
to. But how about yours? Like, what do you think the standard will actually be?
Well, we don't have standard, and you have to convince the court that the evidence you have is sufficient. And of course, the practice is different from one national court to another. We know that the German court accept evidence that are not accepted in French court, but they will align at some point, and just there will be no discovery. So that means that you will have to find the product, analyze the product, and as a defendant, you will have 3 months to file your statement of defense with all the evidence.
Think of the timeline
Which
that
is
we have,
so
the 1
quick.
year.
So if I'm a U.S. company,
That's also an advice we give any client, including U.S. clients. I mean, you have to anticipate a timeline which is so quick that if you're not prepared for a litigation, that's going to be a blow. Because 3 months as a defendant to review validity, think about an infringement, find prior art, align expert if you think you need expert. That's so short.
Yeah, I mean, it's ITC or
Yes,
IPR like speed.
Exactly. The
And you have,
comparison.
the plaintiff has to have, basically bring in our infringement contentions
Yes.
when they do file their initial filing, right? And just very front-loaded, very fast.
Yeah.
Uh,
So written phase, which lasts 6 months. Then you have a phase which is a phase in which we exchange with the judge rapporteur, which mostly will decide whether you need additional evidence, whether you will hear expert, etc. That's quite a short phase. It's a few months, and then you have an oral proceeding, which, as I said, it will be 1 day maximum, maybe 2 days for very complex cases or cases in which you will have a number of patents.
And will
So-
they do validity and,
Yes.
so in one
Well-
day, sorry,
Yeah. I mean, we expect that most of the local division will hear, and that's also something I noted from what Judge Young said this morning. I mean, clearly we expect that most of the local division will hear validity and infringement, deciding first on validity and then on infringement. Bifurcation is an option, but we don't expect the judges to pick this option. Even the German judges, if they are given the option of deciding validity and infringement, I
But
think
they
they're
will
very
happily
happy to
take
do
it in.
so.
Yes.
So so we'll have judgment within a year on validity, infringement, scope of the claims.
with 1 day of hearing.
And you may even have at least an advance on damages, meaning that you may even have a relief in terms of money beyond the injunction.
Sabine, will it be like a pre-conference, though, like an initial, where you meet with the judge,
Yes,
and then, but then it's just your proceeding at the end?
yes. Well, you have a pre-conference, which is, I think that will be close to what is the closest in Europe is currently the CNC that you have before the UK court, which is really like half a day hearing or 1 or 2 hour hearing just to decide what are the main issues
Yeah.
to be discussed.
Yeah.
So giving direction for the oral
Yeah.
hearing. So it's not a movement.
Maybe set the estimated cost,
Yes.
things like that?
Yeah.
Yeah.
Very, very helpful. We're bringing-
So a lot like an opposition or appeal proceeding.
Yeah, pretty much, yeah.
That's it.
Yeah. So yeah, but in terms of being prepared for it, as you just said,
Yes.
be prepared for it.
Yeah.
I mean, what you can always do is when you're concerned about it, or what you should do. I mean, that's what we recommend to our European clients as well. Just monitor your competitor patents.
Can you talk a little bit about that? Maybe Kevin, you could chime in too. Just how do you monitor, competitor
Well,
patents?
typically, what we do, or Kevin, if you want to start, how do you do it?
I mean, it's a hard question because a lot of people, there's a wide range of levels of
That you can do.
competitor monitoring that you can do. Smaller companies are at a distinct disadvantage because they're moving technically fast, they have less resources. Larger companies are at a disadvantage in that they just have so many products. I've been with a company that has a catalog of 100,000 products,
Yeah.
and you just can't. And
Well, I know certain entities like.
even the best third-party monitoring that companies do is extremely imperfect.
Right.
There's
It's
a lot
imperfect
of,
and
and
it's-
there's a lot of praying that you find
Yeah.
that needle in the haystack. Not, it's just, you're gonna miss stuff.
You're going to miss stuff, and then the major point is that someone has to process it in the company. Someone has to look at it, and
It's very time-consuming.
It's time-consuming.
Just doing a good freedom to operate search for a simple component of a product is, that's a 40-hour week for an attorney. And then even if you find something that's of concern, or you find a few things, more time, it's not infrequent to get to the claim and say, well, if it means this, we've got a problem, but if it means this, we're pretty good.
yeah, but that's
Or it's pending. What if it's a pending EP application?
yeah, keep monitoring it. That's what
do you
we
do?
do for our clients. So
It
basically,
goes back to me. These European applications are they're turning from bronze to platinum. I mean, they've gone from good to excellent. They're like the patent. They're like a PCT application on steroids now, as far as a competitor trying to clear possible infringement.
Well, for certain companies like Boeing and Airbus oppose each other automatically. So certain competitors should just. And we dealt with someone that in the past where.
To the freedom to operate thing, I think that's really the shame of easy injunctions, is no matter how well somebody tries to monitor competitors' patents, it's an imperfect science. And
It's still
even an honest-to-God attempt at avoiding the competitor's patent, the infringement will happen. To have an easy injunction within 2 years at the end is quite punitive.
The only thing is you can't really monitor it and try to oppose it. That's the thing. If you find it, well, it's imperfect, but that's at least something.
That's a good point. Oppositions may go up.
I think so.
They'll probably skyrocket.
Yes, and the EPO is very competitive, so they
They'll want
will
to.
want to compete with the central attack before
They
the
will.
central division.
Yeah.
So that will improve the system.
Yeah, definitely, because the EPO is run like a business.
Well, back to your point, the first big award, that'll spark everybody's attention, and all of a sudden the oppositions will likely go up, as well as just the overall activity. I think from the United States side, where we primarily drafted applications with the thought of U.S. style and everything, it could potentially shift to either where it's fully bifurcated, where you're drafting the European application and the American application, or where you're primarily focused. It could go where you're primarily focused on Europe, because the U.S. is so forgiving. You can bring in a lot of different formats into the U.S.
No, I'm going to have to jump in before former Marine gets mad at me. We're only having a few minutes left. Should I open the floor to questions? Do people have any questions? I got a few thumbs up. Stephen.
For the longest time, I've represented NPAs in the nature of research institutions. And the rule of thumb for decades was if you want to enforce a patent, go to Germany. And even get file a utility model based upon what your patent.
If it's young enough, yes.
So that's still, all that still goes on, but I appreciate that, and you would go to UK to validate the patent. And the question is, I don't think that's changed that much, but I think it might be useful to explain to the audience the difference between the theory of injunctions as a property theory of injunctions versus our sort of equity theory of injunctions. So is it automatic?
It essentially.
Well, I mean, currently in Europe, you're right. I mean, all the, I think, with the exception of the UK, which is outside of the EU in any case, the injunction is a right because it's a property and you want to exclude the infringer from your property. I think the reasoning for the UPC will be slightly different, or at least that may be questionable, because there will be a discretion of the judges to grant or not an injunction if the patent is found valid and infringed. We do expect the injunction to remain a rule, so we will not be in a system like the one you have in the US currently. But there will be room for the judges in some cases to say, injunction is not the proper relief.
Yeah.
And obviously we think that for the NPEs, or at least some of them,
it will be harder. So they will make a deliberate decision on that and look at the case.
Yes.
I think so. That's. I mean, it's to some extent reasonable. To some extent, well, I grew up in that tradition. If you have a valid patent, then it's infringed. And this is the tool that you have. This is the motivation for the other one, either to take a license or stop doing it. I mean, that's what those things were made for. I think that was the initial purpose of it. So,
Regina, yes.
So I see London circled on the graphic, and obviously there was Brexit. The UK left, and part of the delay was that. Has there been a solution for?
Well, there's a political solution, as
Right.
always in Europe. So the transition,
It's a deal.
there are currently discussions because, the one which should get, because the division should be going to the country in Europe in which you've had the highest number of patents filed over the past 2 years. and this one is Italy. So this section should go to Milan, but there's a number of countries in Europe who are not very happy with Italy getting one of the central division. And so we may be having a transition in which it is split between Munich and Paris until the time when we make a decision on where this
For the
section
time
goes.
being, it is split between
Yeah,
Munich and
that
Paris.
won't delay the system, so it will come into force with the two sections, Munich and Paris. And whether we
Well,
will
there
have a
will be a
Milan
full-
section at some stage, we will know very quickly. But
Who's going to have
But it
Yeah,
won't be
that-
London.
it won't be London.
All right, I think that's our time. Thank you very much. I want to give a big thank you to our panelists for coming all the way from Europe and giving us this excellent presentation. We really, really appreciate it.
Thank you.